Equity is a word derived from Latin word equitas, which means even, fair, and equality. In the legal view, equity introduced a legislation which exists by the side of law and which substitute in its case of difference of opinion of the law with impartialness and fair play. Equity remedies were largely intended to fill and provide for situations in which the common law was unable to provide the plaintiff with a fair and comprehensive resolution because of the shortcoming of its remedies. Firstly, the common law remedy of damages is available without restriction, while they are discretionary. Next, they are awarded in the situation where the common law of remedy is unavailable or insufficient. And lastly, they behave against a person, which also means that the court power to determine whether it directed by a party.
There are several types of equitable remedies. First is injunction. Injunction means an order from court to command a person to do something or to abstain someone from doing a particular action. It was summarized in Section 4 of Specific Relief Act 1950. This action also disclosed that this act is given to an ordering party to do the very act which he is under a responsibility to do. It also prevents someone from doing that which he is under an obligation to do. There are several types of injunction. First is prohibitory. This type is the most likely form of an injunction. This injunction is where someone is commanded to refrain from doing a specific act for a certain time. Second is mandatory. Unlike the prohibitory injunction, this type is less frequently granted. This injunction is an order necessary for the performance of a specific act. Next is interlocutory. Commonly, interlocutory injunction is typically only issued after notification, giving the defendant enough time to contest the allegation. However, in an emergency, it can be approved by consideration of or for the benefit of just one side or a concerned third party. Interlocutory injunction also means court order that is only enforced while the injunction is being tried. It is typically granted in circumstances when the plaintiff would suffer irreversible harm if the parties wait for the trial to begin. Next is perpetua. A perpetua injunction can only be granted by a decree rendered at the hearing and based on the merits of the case, as per section 15(1) clause 2 SRA. This means that the defendant is permanently barred from asserting any rights or from acting in a way that would violate the plaintiff's right. Perpetua injunction also means a ruling made by the judge following the hearing of the parties' arguments. And interim. Interim also the types of injunction. Interim injunction is a court-issued directive that takes effect on a certain date rather than waiting for the outcome of the trial. Temporary injunctions are governed by Section 51 Clause 1 SRA and are valid for a predetermined period of time or until the court issues an additional order. They are governed by civil procedure law and may be granted at any point throughout the litigation. Last is quatimate. This injunction is an order that has been given to stop a potential violation of the plaintiff right before it has happened. Plaintiff must demonstrate that there is a very high likelihood of a future infringement and that the resulting harm will be extremely severe. Now, I will explain regarding the principle applicable to the issue of injunction. First is interlocutory injunction. Interlocutory injunction is an injunction issued to prevent a possible infringement of the plaintiff's right before it occurs. The plaintiff must show that both the possibility of a future violation and the severity of the harm that might ensue